It's actually afternoon for you folks, but I am 3 hours behind in Whitehorse. So good afternoon.
Awesome. I do enjoy the Australian approach of just saying good day. Also, I just love all different accents and expressions. So I see that we have people already here. Just in the interest of time, I would like to get things started, hoping that we have some more people join. Oh, and we do. This is exciting. So for those of you who don't know me, my name is Clare Cudmore. I'm the Executive Legal Officer for Court Administration at the Nunavut Court of Justice. I'm so happy to be here at our final session of the Foundations of Civil Procedure in the Nunavut Court of Justice. I'm just going to share. Oh, Nalini, would I be able to get you to enable screen sharing? Sorry, I neglected to check that before we started. Excellent. So I'm just going to share my presentation. So before we get into the meat and potatoes of the presentation, I do just want to remind everybody that I failed at life again and was unable to get my Zoom issues addressed before the meeting. So I can't see all of you guys and the presentation at the same time. So if you have questions, please feel free to just unmute and jump in. And once again, just because I don't, I'm not certain of everyone's preferences in terms of how you like to be addressed in terms of pronouns. I am hoping to just use everybody's first name. So if you have any questions, please feel free to let me know. Let's get started. So today we are here to talk about part 25 of the Rules of Court, which are one of the foundational pieces of trial practice in the NCJ. So for those of you who have been to the other two sessions, you're going to hear some repetition, but I will repeat this. I repeat this multiple times a day, every day. The biggest tip that I can give everybody in terms of civil procedure in the Nunavut Court of Justice is read the rules. Remember that the documents that you file are your first impression with the court. And that first impression gets repeated every time you file something. So love the rules. They're not perfect. Sometimes they can be, they are cause for discussion or debate, but love the rules. They are your friend. Also, know which rules. We have a number of different rules in the NCJ. There are divorce rules, there are probate rules, the general rules under the Bankruptcy and Insolvency Act apply in the NCJ. So know which rules apply to the matter that you are dealing with, and always, always, always double check the rules. I'm also just realizing that I should add a number 4, which is don't forget the practice directives, because the court has a number of practice directives that apply to proceedings as well. So let's just do a little bit of a refresher about why civil procedure is important for those of you who are just joining us in today's session. It's about access to justice for your clients, particularly with civil matters. The paperwork that we file, the processes that we have to follow are how we get our clients' matters to court. And so access to justice is a huge reason why you should feel comfortable with civil procedure. In the past couple of sessions, when we were talking about particular types of pleadings, we discussed some of the case law that has found that lawyers can be found professionally liable for mistakes or issues with their pleadings before the court. So costs against a solicitor personally are a thing. I would encourage you to take the time to consider the requirements of civil procedure. One of the things that you should be refreshing yourself on and keeping an eye on case law and direction. Civil procedure is also a really important part of effective advocacy. The court, I promise, the judges read the material that you are filing, and written material is one of the most effective advocacy tools that you have. Civil procedure also ensures timely access to the court. There are rules and requirements and hoops that you have to jump through. And if you have problems with your documents or you have problems with deadlines, that delays your matter being before the court. I always like to give a shout out to the competency requirements in our professional code of conduct. We as lawyers are required to be competent in the areas that we are practicing in, there are requirements in part 3 of the rules of the code of conduct of Nunavut, and those rules apply. You need to know how to do these things correctly because you are expected to be competent to do those things correctly. And don't forget that your pleadings, your civil procedure steps before the court make an impression, right? And when you do things correctly, when your pleadings are beautiful, when you are following the rules, that makes an impression and is noticed. So I also am going to do my standard. This CLE does not intend to teach you everything that you might know about everything in the rules and everything that might come up. So we are here to focus on part 25, and part of this whole foundational series is to help you get comfortable with understanding the processes and procedure and some of the considerations that you should think about when preparing things before the court. So what are we talking about today? We're going to start by talking about entry for trial in the NCJ. We're going to then dive into some more detailed discussions about what the heck trial readiness is. We're then going to move to the next step of the proceedings and talk about trial records, trial briefs, and witness summaries. And then we're going to clue things up with some key things that you should remember. So, entry for trial. Note, like I said, this CLE focuses on part 25 of the rules, and we're going to focus on Form 18. And as you know, you can have a trial in a number of different areas, and there are different ways to originate processes before the court. But for today's training, we're just going to say plaintiff and defendant. But if you are asking for a trial on the basis of an originating notice, obviously those terms would change. Also, I just want to give you the heads up that today we are talking about judge alone trials. This is not going to be dealing with anything to do with civil jury trials, which would be a fun thing in and of itself, but not today. So one of the things to remember is that the rules, part 25 of the rules, really is a gatekeeper to the trial courtroom. Part 25 is one of the shortest sections in the NCJ civil rules, but who boy does that section have a lot of power. It contemplates making sure ultimately that the parties are ready to go to trial. Note that I'm stressing that you are ready to go to trial. Other thing that we're going to talk about that sometimes counsel can forget, Part 25 also contemplates that the litigation otherwise stops when you get a trial date. Okay, we're going to be talking, spoiler alert, about something called the close of pleadings, and that's important to know. It anticipates that you have confirmed the evidentiary record and that your briefs are ready, that you're good to go, and that you not only have done all of that, but you have confirmed your expectations about appearances, about time, about the trial date, that you are good to go. So one of the big practice tips from today is I strongly recommend that counsel keep part 25 in the back of your mind from day one. Okay, because part 25 means that you have done everything that has happened before in the proceedings, and we're going to talk about that. Okay, so I just want everybody to make sure that you are reading part 25, that you know it, and that you love it, because if you want to have a trial, it is a powerful tool that's going to help the gatekeep you from a trial courtroom if you haven't done some of the stuff that's required under these rules. Other thing to remember, like I flagged earlier, the court also has practice directives. And those practice directives and requirements can, from time to time, delay and impede your ability to proceed with your trial. One of the things that the court sees is an expectation sometimes by counsel who have not reviewed the practice directives, have not flagged the sections in the rules that require in-person appearances. You know, the PD requires that remote appearances for trial matters are the exception and not the rule, right? So you want to be thinking at an early stage, am I able to be here? If I can't be here, I need to make sure the court is okay with that. You want to make sure that if you have witnesses that might need to appear remotely. Also, I'm going to flag, you also want to be thinking about where your trial is happening. Because if you want a remote appearance by way of like Zoom or video conferencing, and you're talking about having that your place of trial and your statement of claim is listed in one of the remote communities on the circuit court, that's something you want to flag at an earlier stage, because the court needs to ensure that the technology is going to be available at the anticipated trial to be able to facilitate that appearance. Okay. Also, don't forget the rules require, as does the Legal Profession Act, that you are authorized to practice law in this jurisdiction. So never forget PD 45, because sometimes counsel turn their minds to it when you're filing documents and you forget that maybe you're restricted. You filed your certificate of readiness, your Form 18, 4 months before your anticipated trial date, because you are on top of it, and your RIC expired a month before the trial, right? The court checks these things. So don't forget about PD 45. So that's the practice tip that's coming out of this slide. Don't forget about the practice directives, because things will come to a screen. If you call the court the Friday before your Monday trial and say, oh yeah, no, what's the Zoom? Because I'm going to appear remotely, things are going to come to a screeching halt. And then the court is not going to start from a place of happiness that the issue of remote appearances wasn't addressed in advance. So let's talk about trial readiness in the NCJ. Why is trial readiness important? Trial readiness is important, people, because there are 2 ways in the rules to get a trial date for a civil matter. One, subrule 319.1 requires that you complete a certificate of readiness. And not only that, it requires that if you are filing a certificate of readiness and you want that trial date, all of the counsel on the file have to sign it. So counsel for the plaintiff, counsel for the defendant, if there's a third party, right, if there are other parties associated with the matter, each of you have to work together to come and complete that certificate of readiness. And if you file that certificate of readiness, then the clerk provides you with a trial date. Once the clerk provides that trial date, so what happens is you coordinate with the trial coordinator about when the trial is going to proceed. You get that date, and when you are requesting the clerk to enter it for trial by filing your certificate of readiness, you are also required to file your trial record, which we're going to talk about in the next section of this training. So what happens if all y'all can't agree about the multitude of things that are on the certificate of readiness? Great question, and the answer is in the rules. So if you are having challenges getting all of the parties to sign a certificate of readiness, there's a process required in the rules under subrule 319 sub 3 that you actually have to make an application to the court to request an order setting the matter down for trial. Now, perhaps you have done this through the context of some interlocutory proceedings that are happening in advance of you getting ready, but it is absolutely contemplated that either you are going to have a certificate of readiness that has been filed quite happily, signed by all of the parties, agreeing that the matter is prepared to proceed to trial, or having certain conditions on it saying, listen, we want to get a trial date because we are good to go. We only have one discovery that's going to be proceeding next month, but we'd like to lock down that trial date because we are all good to go, right? Or if you are dealing with a matter that is undefended, you have to file a certificate of readiness. But if you guys, if there is fundamental disagreement about whether or not there are interlocutory proceedings or undertakings that are outstanding, or someone just disagrees with you that they're ready to go, you have to drive that matter forward by making that application under subrule 319.3. Now, important thing to highlight, Rule 320. One of the procedural realities, once that certificate of readiness is filed, or when that order is granted by the court because you've contested and asked for a direction that the matter be set for trial, pleadings close. There are not supposed to be any further interlocutory or interim motions filed or any further pleadings filed after that certificate of readiness lands in the court file. Once that matter is set for trial, you're supposed to be done, unless there's been some type of direction to say that there's outstanding things that are going to happen. And if after setting that matter for trial, after that matter is entered for trial, there is some type of interlocutory thing or something goes sideways, the rules require that you make a motion seeking leave to proceed with an interlocutory step or the filing of some type of pleading. So don't ever forget that litigation, all of the preliminary, interim, figuring out of things before we can sit with a judge in a trial, is supposed to happen before pleadings close. Again, that's not to say you can't make a motion, but it does require leave, which means if you have a certificate of readiness on file and you try to file a motion that is not a motion requesting leave or does not include that you are requesting leave to file this particular motion, the registry will not file it because pleadings are closed. So let's take a look at the certificate of readiness. This is going to involve me flipping screens, so stand by. Flipping. Okay, so I'm trying to make it as big as possible. Is this really visible for you guys? Going to take silence as yes. Okay, so this is Form 18. This is the certificate of readiness that is required under Part 25 of the rules. So like all of the other annotated forms, you'll see that there are particular rules that are endorsed in red on the document to help you understand where all of these requirements are coming from. But I do want to note, remember that your general heading depends on your proceeding. So this is based on the general heading in a statement of claim. But if you have proceeded by way of petition under the civil rules, because remember the divorce petition is different, if you if your matter originated as a petition, that general heading is different than this. So belts and suspenders, check to make sure that your general heading is correct, that your court file number is there, all of the things that we've talked about in the two other trainings. Okay, so certificate of readiness, we've got that document heading so that the court knows what it is that you are filing. But you will note this certificate of readiness is contemplated that we, the solicitors for the parties, certify that all of the pleadings, discoveries, interlocutory proceedings, and expert examinations that each of us intends to do or have done have been completed and filed, right? So understanding that today's session is about Part 25, that's a good indicator that there are other sections of the rules, like Part 18 that talks about expert evidence. There's sections about discovery proceedings. There's requirements for pleadings. You are saying that you have complied with all of the requirements of the rules in relation to those documents as they are required in your matter. So you are also confirming that all of the undertakings have been performed. You're confirming that you and your clients are ready to proceed to trial, because it has been, sorry? Did somebody have a question? Oh, no, okay. So because I will tell you that it has been experienced that lawyers will set a matter for trial and sometimes their clients don't show up because maybe somebody forgot to mention that. So that is a nice flag to ensure that your clients are being informed that the matter is going to be going to trial and that your client is available on the date that has been provided for the trial. This section here, that is Rule 320 in action, right? This section says that you are certifying to the court that you will not initiate any pleadings, discoveries, or interlocutory proceedings after the filing of the certificate without leave of the court. Now, and I can endorse this on the document before circulating it. I'll make a note to do that. You can modify this if you are asking for a direction to say that, we've got a discovery that we need to complete and we're confident that it's not going to cause problems. You could modify that accordingly, because again, the clerk is going to be checking to see if there was any direction in the certificate or from the court about subsequent steps following the close of pleadings. So turn your mind to that. I've also noted right here, and I was not able to do it at the bottom of the page because of the margins that are required in the Nunavut Court of Justice, but please consider putting page numbers on your certificate of readiness, because it is not a short document, and it is always helpful in case, especially in this jurisdiction where lawyers from time to time will email documents and they're being printed by the registry, page numbers are helpful. Okay, so you are also required to state that what the nature of the action is, and that's because y'all need to agree on it. So the court wants to know that you agree about the nature of the action. This is an opportunity for you to reiterate what the relief being claimed by the plaintiff is. And again, you'll see purple are the kind of practice tips and suggestions that I have aimed to helpfully include on the document. One of the things that you will see flagged in a lot of this training is, your written pleadings are going to a judge. You want to do everything you can to make sure that it's easy for the judge to follow what you're saying, that it's easy for them to read. Don't use 10-point font. Legit, the rules allow you to use 10-point font. Please don't use 10-point font. The judges can't read it. I can't read it. So if you are setting out multiple grounds of relief, consider doing it in a consecutively lettered paragraph so that it's easier for the judge to read. Fun fact, it's also easier for you to refer to in oral advocacy. So if at some point something in the certificate becomes contentious, it's easier for you to refer the judge to on page 2 under paragraph 2, the relief claimed in subparagraph E, it says this, Your Honor, right? Just easier for reference, in addition to being easier to read. Same thing, you're required to note if there are counterclaims, or note that there are no counterclaims. So again, if there are multiple heads of relief being claimed on the counterclaim, consider doing that as that easier to refer to bulleted list, okay? If there are other parties, and I will point out, I've gone a little rogue because the form of the certificate of readiness doesn't necessarily reflect things in a bulleted, easy to follow way. So I am suggesting that you would consider doing that because it's easier. Ultimately, the form doesn't necessarily require that you do that. But if you are setting out the third parties, again, lists, judges love lists, and it's easier for everybody to read lists. So paragraph 5 on this form also requires that you indicate whether or not you've considered the possibility of admitting facts. So you are either going to say that no admission has been made, or the form says admissions have been made and filed with the clerk. Now, my practice suggestion would be that you would consider changing that language a little bit to say admissions have been made and filed with the clerk in an agreed statement of facts filed on date. And that's because from time to time, particularly over the life of litigation, there may be more than one admission. And again, the purpose of civil procedure is for you to make things easier for the judge to agree and find the information that you are wanting to refer them to, right? And so it is helpful to designate exactly what document title and what date that they should be referring to. You may even want to say if one party filed it on one instance and another party filed it on another, you could even say, make reference to those parties. But all of those minor tweaks help make it easier if the judge is reading your certificate of readiness and then says, well, what are those facts? And then he or she goes into the court file, it makes it easier for them to find the document and admissions that you're referring to. Now, I am going to flag, because again, we don't have all of the time in the world, unfortunately, to go through the entirety of the rules. There are procedural requirements for expert evidence in the rules. There's a whole section about it. You may want to take some time to review that part of the rules if you are referring to expert reports. Now, I am also going to point out that this is one of the sections of the report that I have gone a little off script on in terms of how it is presented on the form, because the presentation on the form is fine if you have one expert report or one each, but if you are dealing with multiple expert reports, I highly suggest that you consider laying out how it is on this form, because it makes it, again, easier for the judge to refer to if you are dealing with multiple people. So I'm suggesting that you would break it up to make it clear and easy to refer to about whose expert reports, which party's expert reports, and which expert you are required to give a brief list, but you're required by the form to give a brief overview about the nature of the report. And then there's also, and again, this is a change, on the form, it has a separate paragraph that says whether or not the report has been given to the other party. I'm suggesting that you would put that with the report so that it's easier for the judge to say, okay, so there's this report, but they haven't got it. Okay, but everybody has this report, etc. And then I'm suggesting that you would break out the responding reports in a separate section. Same way. Again, all of this is designed to make it as easy as possible for the judge to understand what you're saying, but also I would suggest it also makes it easier for, if you have one party who is kind of trying to get this certificate prepared, if it's easy, you want to make sure that it's easy for everybody to be on quite literally the same page about the information that's included in the form, right? So then there's a section where you are required to note the issues in dispute. And I'm going to flag that this section of the certificate of readiness is really important, because as we all know, sometimes the life of litigation is a long time, and you can go from like baby to toddler to teenager and to adult, and maybe some of the things that were in dispute when we were teenagers is no longer in dispute. And so it's important that the court is clear about and able to focus on what the issues in dispute are. And again, this is your opportunity to set that out in a way that's clear for the judge to understand. Now, I am also going to point out this next section is a change from how it's presented in the form, but I do suggest that you consider doing it this way. The form has a table that is a little bit condensed and can be hard to read. So I'm suggesting that you would actually list the witnesses. Note, again, because we've got some other rules that we're not talking about today that apply, You're required to list your ordinary witnesses and your expert witnesses. And don't forget, Rule 320, Subrule 326.7 says that the requirements for expert witnesses in relation to some of the procedural requirements that we're going to talk about later in the training are a bit different. So you want to make sure that if you're listing somebody as an expert witness, that their, for want of a better term, qualification as an expert follows the requirements of Part 18 of the NCJ rules. So pro tip, there are other sections of the rules that come into play. Don't forget to look at those. Today we're focusing just on entry for trial. So we've gone through the witnesses are very easily set out. You are also required to indicate what you anticipate the duration of the trial is going to be. And people, this is very important. The estimate that you give for the trial is quite literally what the court uses to determine how many trial days are going to be allocated to you. And so one of the things I will flag is that if there is an expectation, as you'll see in the next paragraph, that you are actually going to be able to provide an indication of when you might be available for a trial date. And so if you are at the stage of trying to determine when and how long your trial is going to be, and how that trial might be scheduled, when you are working on this part of your form, that is the time to be in communication with the trial coordinator at the NCJ. And if you have some dispute about the availability or when the matter should proceed to trial, that may be something where the parties need to consider whether or not an application has to be made under Subrule 319.2 to ask the court to issue an order, because I will tell you that if there is an indication that there are parties who are trying to set a trial for like a total time of 100 days, you're going to be hearing from the court about doing some type of meeting to determine what is actually required. So that's the importance of the time estimate. There is also implicit in this document, because all of the parties are signing it, that you are coming upon a date that is workable for all parties, right? And remember, fun fact, Rule 321 requires that the trial proceed at the place of trial listed in the state of claim. And if you want the trial to proceed elsewhere, you are required to make a motion to the court to change that. So if you are intending to put a different location on your certificate of readiness that is listed on your statement of claim, it would be expected that there would be a motion and an outcome on file that would support making that change. Next step, all of the lawyers need to be listed. And so again, the form has a certain kind of table requirement. I'm suggesting, to make it easier for everybody to read, that you would list the same way you list in your signature and just list everybody's contact. I also flag that in 2023, many of us communicate by email. So please consider, you will note I've listed email on this form. Put your email on the form as well, please. It is very helpful. So this is the certificate of readiness. And again, it is contemplated that it is signed by all parties. It is also contemplated, in accordance with the Convention of the Nunavut Court of Justice, that y'all would put a backer on it. Now, 9 times out of 10, one party is quarterbacking drafting this certificate of readiness, right? And so generally it's the quarterback party who would put their address on the back because they're the ones that would be contacted to coordinate with the other parties. But really there is nothing to say that you couldn't put all 3 addresses on the back. You fill your boots, but please do remember to put your backer. Please do remember to ensure that the style of cause is appropriate and the general heading is appropriate to the proceeding, that the court file number is the court file number that you've been using throughout the proceeding, and that you are including roll numbers or RACs as appropriate. So, are there any questions about the certificate of readiness? Okay, so I'm just going to stop the screen share of the certificate of readiness, and then I'm going to go back to the presentation. Somehow, there we go. Okay, so actually before we move on from the certificate of readiness, I just want to point out that that certificate of readiness is a very helpful tool to keep in mind when you are engaging in civil litigation in Nunavut, because it is quite literally designed to ensure that you have turned your mind to the necessaries of what needs to be ready, right? And so when I started at the beginning of this section of the training to say keep part 25 in the back of your head, I like strongly encourage you to don't just look at that certificate of readiness when it comes time for you to keep a trial date, to seek a trial date, because it will help you. You know, it's a bit of a cheat sheet about the things that we have to remember to consider and keep track of if we are seeking a trial date from the court. So let's now talk about, so we've got our certificate of readiness prepared, or we've gone through and prepared our motion materials to seek an order under 319 sub 2. What are the other requirements? So in order for a matter to proceed to trial, there are certain like documentary requirements in terms of preparation that you are required to consider. So there's a trial record. You're required to file a trial brief. You are required to prepare and serve witness summaries. You are required to consider the form of appearance, right? And I flag that because, again, it is not infrequent, both in chambers practice and in trial practice, for parties to make it all the way to the starting gate and forget to flag that perhaps they don't intend to be present. So I like to flag that often and loudly, don't forget. So let's talk about each of these requirements individually. So the trial record and service of the certificate. So subrule 322.1 requires that the party that enters the action for trial file a record for the use of the trial judge. And basically what the trial record is, Your Honor, here are all of the pleadings that you may be referring to throughout this trial, right? And don't forget, if you have, remember how on your certificate of readiness, there's that section that says issues that are still in dispute? If you have resolved matters through interlocutory proceedings or agreements or what have you before the trial, you are not required to file pleadings that relate to those matters. You only have to file pleadings in your trial record that relate to the substantive issues at trial. Now, one of the things I am going to flag is that sometimes, from time to time, the contents of a trial record can be contentious. And so that's something that you want to turn your mind to, because when you are confirming that trial date with the clerk, you are actually supposed to be filing that trial record at the time that you are getting that trial date. Rule 323 requires that the party who is entering the matter for trial serve a copy of the certificate of readiness and trial record on every party within 5 days of getting that trial date. Now, I will flag also, one of the things that's important to remember as civil practitioners is anytime you see a requirement for service in the rules, don't forget proof of service. You would probably be surprised at the number of times court matters get delayed because there's been a requirement of service and there's no affidavit of service on the file. There's no proof of service. And these are the things that delay. So one of the practice tips is start a practice in your mind and in your practice of remembering proof of service, right? Remember that there are practice directives that create particular requirements if you are serving documents via email. There are requirements for particular types of documents in the rules about how they are to be served. So once again, read the rules, double check the rules. Don't assume that because you serve a particular document a particular way, that all documents are required to be served that way. That's just a thing that I like to remind people of. So, ooh, fancy. I don't know why that did that amazing animation. So things to think about when you are preparing to file your trial record. Remember, talk about the trial record, consider the trial record when you're preparing your certificate of readiness, because it assumes as part of the process that you are going to have that document to file when you file your certificate of readiness, which means the parties have agreed about the trial record. And if the certificate of readiness is filed and the party who is entering it for trial files that trial record, pleadings are closed. So that means you will have to, if you have not consulted with the other parties about the trial record and there is subsequently a dispute, you have made more work for yourself because you are going to have to make a motion asking for leave because pleadings are closed to dispute the contents of the trial record. And timelines are tight in terms of the requirements for service. And so belts and suspenders, if you are working with a counsel on a certificate of readiness, don't forget the trial record. Don't forget to talk about it. Ultimately, that is up to you. Practice tip, talk about it. And also, again, back to this overarching reality that the documents that we prepare and file are there to be helpful to the judge. Check and double check your trial record to make sure that it is prepared correctly, right? Are the tabs, you have a table of contents that says, this is what is in this motion record. Are those numbers correctly? Are the documents included in the trial record that you're trying to file? So it has happened from time to time that a trial record refers to a number of tabs and a number of documents, and they're not actually in the record that's filed with that the parties are attempting to file with the court, right? I would suggest that once again, you may want to consider paginating the document so that you can refer to a tab and a page number. Particularly if the documents, the pleadings in the motion record don't have page numbers, it makes it easier during oral advocacy to refer to it to the judge. Also, your trial record should have a cover page that includes the correct style of cause, the document title, your general heading should be correct. It should have a backer. If the trial record is being prepared by one party, and you're putting, because as you would put all of the party, like the lawyers and stuff on the bottom of that cover page, please make sure that you are somehow indicating which party filed the document. So for example, good practice and conventional practice would be to bold the name and address of the person who is filing, right? So think about these things because, again, these are things that don't necessarily make the best impression in the court. It also is just not a great feeling if you are mid-trial asking the court to refer to your trial record and the court turns to tab 5 and you say, well, I'd like to refer to the affidavit of Clare Cudmore, and the court looks at you, pulls their glasses down and says, counsel, there's nothing at this tab, right? That's not a great feeling. So check and double check before you file. Practice tip. Again, the life of a civil litigation file can be long. Sometimes, you have a lot of files going on. You may be dealing with a number of things at the same time. You are able to request something called a procedure report from the civil registry. And that procedure report will tell you exactly what documents have been filed with the court. And so that can help you when you're preparing your trial record. And you're allowed to request that through the access to court records process. So don't forget to ask, and then check your records against what is actually in the court file. Because again, that's a great opportunity. If you filed, for example, your trial brief and your trial record, and you're 10 days before the trial, and you are looking at that procedure report and you see, oh shoot, I forgot, there's no affidavit of service on this file saying that I've served the trial record. Also, please do not forget, the court requires hard copies. Hard copies that are bound and tabbed. And the general conventional requirement is the court wants to have all of these documents, your trial record, your trial brief, in their hands at least a whole week before your trial date. So 5 business days. So if you have a trial on a Monday, you want to make sure that the hard-bound, beautiful, tabbed, correct, complete copy of your trial record is provided to the court registry by the lay-ins at the court registry by the Friday before, so that they can send that up to the judge on the Monday. So my trial, it's Friday, I'm sending my trial record. The court has the whole week, Monday, Tuesday, Wednesday, Thursday, Friday, to review that trial record, because the following Monday is my trial date. So you always, as a good practice, want to make sure that a judge has that thing to look at for at least 5 business days before your trial, because they are looking at the file. They are preparing for the trial the way that you have been preparing for this trial. So hard copies at the registry. And I flag that, counsel, because if you are not in Nunavut, you want to make sure that you are sending it with enough time to get here, right? And on top of that, helpful fact. Remember, if you are dealing with a civil trial on a circuit, the judges and the court staff generally leave, depending on where the matter is occurring, they are generally leaving the weekend before the trial. So if you are dealing with a circuit matter, I would strongly recommend that you consider thinking about having it at the registry with enough time to consider that the judge is going to be traveling during some of that time. So things to think about. Let's talk about trial briefs. So trial briefs are a requirement of the rules. Subrule 325.1 requires that each party to a trial file a trial brief with the clerk. And you are required to file one for the judge and one for every party. And there are requirements on the contents of the brief. That should say summary. I'll fix that before I circulate the slides. It's because I'm wishing that we had more summer weather in Nunavut. So remember, you have to include a summary of the facts. You have to include a summary of the issues. You have to include the law that you intend to rely on. Now, I am going to point out that it is a good conventional practice to consider including, if you are going to be asking the court to consider your position on the trial, consider that in terms of what you are including in your trial brief. Remember, you are preparing this document to assist the judge. So remember 1.5 spaced, single-sided, consecutively numbered paragraphs. Check your references. If you are referring to a tab in your trial brief, if you are referring to a particular pleading, make sure you are referring to the correct one. Ensure that your general heading is correct. Ensure that your style of cause is correct. Ensure that your backer. And most important, Make sure that it's clear whose party the brief is, because you would not believe the number of times that we have briefs land and we cannot tell which party has filed the brief by looking at the document, which is less than helpful. So consider for your document title that it would be the plaintiff's trial brief, the defendant's trial brief, the third party's trial brief. You're going to bold your address on that cover page. All of these things help the court understand whose information they're reading. And again, five business days. You want the court to have time to review these documents and prepare hard copies at the courthouse. Okay? Now, let's talk about witness summaries. Did you know, and I know that you did because you reviewed the rules before coming to this course, and you have reviewed the rules any number of times as a civil practitioner in Nunavut, but Rule 326 requires that every party is to serve a summary of the evidence of each ordinary witness on or before 10 days before the trial. And that's an important, I bolded ordinary witness because again, that doesn't apply to expert witnesses, but turn your mind to the fact that you are required to file that summary. And the rules also have helpful information in sub 1 to say what a summary of information is. So this rule should be one that if you are proceeding to trial, you are very familiar with. It is required under subrule 326.4 that the witness who is providing the evidence must sign and verify the truth of the contents of the summary. If you are unable to have your witness review and sign a summary of their anticipated evidence, you as counsel are required by subrule 326.4 to provide a certification of why the witness is not available and what you anticipate that evidence will be. Now, things to consider. You will note in reviewing that rule that you are not actually required to file those summaries with the court. Okay? What you are required to do is serve those witness summaries on the other parties. And remember, what did we just talk about? Proof of service. You want to have in your back pocket your affidavit of service saying, why, yes, here's my affidavit of service proving that I served my friend with this witness summary. Because these summaries can become a procedural bone of contention in the court. Parties are able to object to if you're not providing a verified witness summary. And so, you do want to turn your mind to this requirement at an early stage. Practice recommendation. If you are intending to call 7 witnesses, consider whether or not you actually want to create a party's witness summary book. So like the plaintiff's witness summary record, as it were, so that you have a tabbed table of contents. I somehow made that a verb. Well, we'll go with it. You have a tabbed table of contents document that's easy to refer to that has all of your witness summaries in it. I suggest considering that because it makes it easier for you to serve one document than to have separate affidavits of service and trying to track people down individually. Again, from an oral advocacy perspective, if you do have to end up filing that document in court because the witness issue becomes contentious, it's easier for you to refer the court to the particular tabbed summaries than having 8 or 9 or 12 documents floating around stapled. So that's not a requirement, but again, in the world of procedural things that make life easier for a judge, something to think about. And remember, the exemption for expert witnesses in subrule 326.7 is specific. It says Part 18 expert witnesses. And so turn your mind to whether or not the witness you are referring to is potentially going to qualify as an expert under Part 18 of the rules. Don't assume, always check. So, key takeaways before we open the floor up to like trial discussions, and then if there's time, depending on how much people want to talk, we could go through like procedural tip sheet that I've created that might help with considerations for some of these procedural requirements. Remember, at every step of preparing for a trial, everything that you are doing is trying to help the judge understand the argument that you are making. That may be an argument about whether or not you have followed the procedure, or it may be the legal argument that you are trying to make. And so keep that in mind, because one, how you are presenting the information and complying with the requirements of the rules and presenting the evidence at every instance in a way that makes it easier for the court to understand helps you. And all of these things, the certificate of readiness, your trial record, a properly prepared, effective, concise trial brief, remembering to serve those witness summaries, remembering to have your affidavit of service to file if you need to, or filing your affidavit of service to prove that you've complied with the requirements of a rule where you are required to file the document, all make sure that the court is able to focus on the matter at hand, which is the trial, right? You don't ever want to be in a situation where the court has to focus on the document or the procedure because something has been done incorrectly or something has been done inappropriately. So for example, consider that as a lawyer, when you are signing that certificate of readiness, you are certifying to the court that you are ready to proceed. And so it's not great if you file that certificate of readiness and then remember, oh, shoot, there were actually like 7 undertakings that haven't been followed up on, and I totally forgot that I wanted to discover this person and I didn't do it, but like I'm just going to do it now, so can I file this, right? So remember, all of these documents are here to make sure that when that trial date comes up, there is nothing that's going to cause the court to say the matter can't proceed and delay justice for you and your clients. So things to remember when you're starting to think about trial readiness. For me, one person's opinion, to me, it's a lot like dirty dishes, right? Because some of the procedural work of preparing for a trial is not thrilling, right? It's not, it's certainly not anything you see on like TV movies, right? But if you keep an eye on these things, if you do the dishes every night, it's easier to keep track of all of these things. And remember, you don't want to be neck deep in that dishwater like 5 days before the trial is supposed to happen, right? That means you are on your back foot. It also means that your trial may be delayed. So think of, if it is not your jam, if it is not something that you love, keep that Form 18 in mind, the same way you would think about how much easier it is not to let them dirty dishes pile up. So some things to think about. I know that there are some people who are attending this training who may be like fairly new to the practice of law, or maybe you haven't had the opportunity to litigate a trial in court. I always suggest go to court, watch a trial. Even if you are even if there's not a civil trial happening and there's a criminal trial, you will still get a perspective on how trial advocacy works. You will see about exhibits being entered. All of this is helpful in terms of building your comfort in dealing with civil trials. And remember, prepare before you go and manage your deadlines. Be comfortable. Start right now knowing that Part 25, the entry for trial, is very much your gateway to a trial. It tells you how to get a trial date. It tells you what you need to do to get a trial date and to keep that trial date and to be prepared that your trial is going to go ahead. So run your practice expecting that matters should never be delayed because of how you're filing documents, how you're preparing your evidence, or how you're preparing to comply with the requirements of the rules. So one of the things that I say to think about is be ready, 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 ready. Be ready to point to the rule that allows you to do something. Be ready to point to a rule that allows you to say allows you to say that someone shouldn't do something. So for example, I'm just going to point out, if a certificate of readiness has been filed and all counsel have signed off on it, or there's been an order saying that the matter is set for trial, and you see that opposing counsel is trying to file an interlocutory motion, you are allowed to point to the fact that pleadings are closed. So be ready to prove that you've provided the appropriate notice. Always, always, always think about, if I'm required to serve something, I'm required to prove it. And be ready to follow deadlines. And understand that the rules, like I said, they're a tool to help you move your matter to trial and to focus litigation. And one of the things that I sometimes find that counsel, particularly those that practice in other jurisdictions, may not realize, the Nunavut Court of Justice is really nimble when it comes to civil matters. We have a regular civil chambers almost every month. There is a civil list that you can get a matter on fairly quickly. So if you are having issues with coming to ground on the preparation of a certificate of readiness, if there are issues coming out of your procedure and discovery, it is we don't have the problems of some of the other jurisdictions that are larger that may have some delays in dealing with civil procedure. And so understand that the rules are very much a tool to help you move your litigation forward if you do engage with the rules correctly and effectively. So this is our final session in the Foundations of Civil Procedure. So I do just want to take a second to say, I hope that you take away at least two things from all of these trainings. And one is to remember that the rules aren't there just to provide you with the forms for court, right? It's important as part of our practice as civil litigators to read the rules, to understand the deadlines, to be knowledgeable about the practice directives, because again, these are tools that help you move litigation forward. You don't have to sit and wait months and months and months and months and months and months. If you are arguing, if you and opposing counsel are not able to come to ground on the preparation of that trial readiness certificate, you can file a motion and